Assignments.
Okay, so welcome to Law of Agency, topic 5. Um, you can feel free to interject anywhere where you feel you don't understand. It's a discussion class, so you're welcome to interject. It's not a lecture, so feel free um, to add or subtract anywhere in between. Constructive
Sorry,
adding
sorry.
and subtraction. Okay, so let's start with the definition. Agency is basically a relationship that exists between two parties. Okay. Um, for example, let's say you're opening a business with someone, and that is an agency. Okay. Maybe you're going to get in partnership with a friend, and maybe you're going to start a software company. That is an agency. Okay, so that relationship that exists between the two parties, um, and they should be able to form a legal relationship, then that is an agency. Okay, anything within the law uh, conf- um, um, confirms it as an agency. So and then an agent is a person who is authorized to act on behalf of another. Okay, so if you're an agent, it means that you're contracted, or you have been authorized to act on behalf of another person. Okay, so some of you may be agents. You may choose to be agents. So some example of agency relationships are real estates, people who buy and sell goods, stockbrokers, software engineers. All those make examples of agencies. So what's an agency relationship? How do you create one? Um, you can create one through express authority. That means that you don't need to write down anything. You just you can even just discuss it orally. Just say, oh, let's form a company, let's do this. That will still create a legal agency. So it doesn't have to be written all the time. A written one obviously is the best, because someone may deny you. It can be your word against the other. However, um, even an oral one is very okay. So you can make an agency through express or a written contract. Joseph, you wanted to say something? Joseph, you're raising your hand. Okay, you change your mind. All right. Kindly mute your mics. Unless you have something to say, then you can unmute so that we can hear each other very well. Okay, the other way of creating an agency is through apparent authority. That means that you don't have an agreement in existence, but the way you have been acting makes it an agency. You never said anything to each other to begin a company, but the way you started, maybe you're doing a software design company, but you never really came together to discuss it. However, the way you've been acting, the way you've been doing things together, still makes it an agency. The way you conduct yourself makes it an agency. Especially some of you guys who get you get a girlfriend, even if you haven't said anything to them, but when you start living together, doing things together, you basically married. Okay, so you don't come to court and deny that you don't know that person, but the way you have been acting already has joined you. So that can be used in court um, against you, the way you conduct yourself. Okay, then ratification. Also, there is no express or apparent authority in this case, but you've accepted a contract, okay, that is negotiated on what? On behalf of you. Like, for example, you authorize someone to act on your behalf, then that still makes it an agency. It still makes it legal because you authorize someone to come into agency with you. Okay, so what is an actual authority? An actual authority is a principle. Okay, it's bound by the actions that are written in the agent's authority. For example, you could write down something. You could probably imply something by the way you've been conducting yourself. Maybe you paid for, you went to you went to a shop and bought a DVD. Then you have come into actual authority. The moment you buy something, even if you didn't say that you're uh, in 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 agency with the other person, you still bought goods from them or a service from them, and maybe you got a receipt. That also makes an actual authority. It can apply in court. Okay, so it can be oral, it can be written, or it can be implied by the way you conduct yourself. Okay, and also it could also be based on someone. If you appoint an agent, okay, maybe your secretary to act on your behalf, it also becomes actual authority. So actual authority looks at how how legal is that the binding of whatever you have discussed as an agency or the way you have been conducting yourself. So so actual authority is basically that principle that is bound by actions, like you say that you're going to be in a relationship with this person, a business relationship or personal relationship with this person. Also, it could also be the way you have been conducting yourself, buying goods, living with this person. Also, it can be implied by you authorizing someone to act on your behalf. Like you can have your secretary do it, your agent come in as a third party. Okay, so that is what actual authority is. So actual authority is what stands in court. What are you going to argue on court? When you go to court, what is going to bind you? Okay, so it's that written document or the way you have been conducting yourself, or it could be that you appointed an agent or someone to stand in for you in this agreement. So that is actual authority. Then apparent authority is where there is a third party. Okay, a third party means that you did not really you're not bound by things like a written contract or the way you have been acting, but you knew it as a third party. Okay, you came to know about it maybe through someone. That's what you're calling apparent. You're like a third party in this whole business. Okay, maybe there was a business coming in place, and then you knew about it. Okay, maybe you're an employee, maybe you're the manager, so you become an apparent authority. You're a third party. You've been observing, you've been part of the whole thing. Maybe you're a secretary. No one has given you principle to act, but because you have been participating in that whole business, then you become an apparent authority. So an apparent authority is usually a third party, okay, who is also entitled to that. If you're looking at also a family, like the children are apparent authority. They are third party. They didn't come into agreement in this whole marriage thing, but then they find themselves in that relationship. So they become apparent authority. Okay, if you're looking at a company, the business employees become the apparent authority. Okay. All right, so I hope we understand that one. Yeah. Okay, make sure you mute your mic. I thought you're responding to guys, please mute your mics. Let me see who is that talking. Guys, please mute your mic.
Galaxy, can't you mute yourself?
Galaxy, Jonathan, please, Andy, mute your mics. Okay. Please mute your mic unless you have something to say. Then we also have, in the scope of the agent's authority, we also have ratification. Ratification is when a principal is held liable on basis of the words or actions that you have been doing. For example, like I said, if the way you've been acting, okay, like you're part of the business, okay, makes you a principal in that business, makes you, this is what you are now calling ratification, okay? So you basically established yourself in that place. You're a third party, by the way you have been acting also makes you part of the business, okay? Maybe you've been really putting in so much time in this business. Like in IUA, I'm basically a third party, but the way I've been acting, doing my work and all that can make me a principal in that area. So I feel ownership of the company, okay? So ratification is basically, it's a principle that will be held depending on the words or actions or the contract made without particular authority. Okay, you did not try to become partner in that business, but because of the way you have been acting, makes you part. Okay, so that is ratification. Okay, sec. Okay, then when is an agent liable? When are you liable to be held for certain actions? If this business is sued or if something happens, when are you going to be liable? Okay, you're going to be held liable if you're acting on behalf, okay, of that principal. Okay, if you're acting on behalf, you're basically liable. That means that as long as you're an agent for that principal, you're a third party in that agency, you're going to be held liable. Okay, for example, if IUFOs get some issues and I need to come in, definitely I'll be held liable. Okay, for any legal matters that come in, because with the way I've been acting, basically part of IUEA. Okay, though I've not come into a particular agreement with the shareholders, but I'm basically part of it. And my liability comes in because I also have a contract as a lecturer. Okay, but even if I did not have a contract, with the way I've been acting, teaching, doing this, definitely I become liable. So you become liable when you're acting on behalf of that principal. Okay, if you're acting on behalf of IUEA, you become liable. Okay, you guys are also liable to anything that happens to IUA because you're students. The way you have been acting, whether you have not registered as a student, whether you have registered or registered, you're still liable. Okay, because of the way you have been acting, you've been coming to the school, you've been participating, so that is when you're liable. So you're held liable if you're acting on behalf of that principal, whether you're third party or not. And you can also be held liable if you are authorized. That means that if you have been signed as a student, if you have been signed there as a partner, if you have been signed there as an employee, you also become liable to anything. If IUA goes to court, they can call you as a student, as an employee, because you're already registered with IUEA. Okay, if you're a partner and you come up with your business and you made an agreement with your partner, if anything happens to the partner, you're going to be liable. If that partner is arrested, you're also going to be liable, as you're going to, usually the term that they use is an accomplice. Okay, so whether you have signed in the second bullet, you need to be authorized. Okay, and then in the first bullet, even if you have not been authorized, as long as you're acting on behalf of the client, or the way you have been acting makes you liable. So these are some of the responsibilities of an agent. Some of you are going to become agents, so these will be your responsibilities. You have to comply with the agency's agreements. Okay, so whatever terms and conditions they have given you, you have to comply with them. If the person who has assigned you as an agent has given you instructions on how to handle their company, you follow those instructions to the letter, because you're acting on behalf of the other person. It's like you're the other person. Okay? And also, your personal performance has to be at the highest degree of trust. That's why you cannot separate business law and ethics. You have to be trustworthy because you're acting on behalf of the business or on behalf of the other person. So make sure that the other person or the business can trust you 100%. Like for example, I'm here teaching you, but my boss, my dean, is aware that I'm handling you with the best of care. She's trusting whether I should also be online. Okay, should be also attending the class, but she's trusting me to make sure that I handle the class very well. So you have to be at a high degree of trust because the other person who hired you will not always be there to watch you. So you have to be ethical as you're handling your agency business. And also the last part is the fiduciary holding trust. Fiduciary duty means that you're going to hold trust. It's one of the strictest care that we have in a relationship. It's trust. It's like the personal performance that comes from the heart, but fiduciary duty, you can even be sued if you're not holding your trust at the highest degree possible. So fiduciary duty, you can even be sued on that issue. It means holding trust for the other person. So someone can say, I've given you my fiduciary duty. Okay, that means that legally you're basically the other person. They have given you that trust to manage the company or to manage the sale of the company or to manage the employees. So you have that fiduciary trust and you can be sued in court because of that. Sunny, I saw you raising your hand.
Yes, madam. So I have a question about these agent things.
Yes.
So when a guy kind of agent agreed on behalf of the principal on something on which the principal did not agree on his own, so can they kind of reject, for example, an agent sign a contract on behalf of the principal and then the principal kind of reject that contract? So is that possible? How are they going to resolve that?
Yes, it's possible, but it comes down to what you agreed with your principal. What did you agree on? So they should be, that's why a written document is much better than oral, because oral someone can deny you, but written, you can say, no, this is what you agreed on, this is what you said, okay? Because someone can deny that they did not tell you to do that. Either the agent or the principal can deny. Okay, so it's possible. That's why they usually say that it's your word against mine. So it's very possible. But to be on the safe side, always have something written out, a written document. Okay. So for me, when I'm doing business with anyone, as if I don't trust them 100%, I tell them to write down, because people can break your trust. Okay. So it's possible. The agent can go there and say his own things. It's very possible. And also on the other side, the principal can deny that they told you to do that. So either way, you have to sign a contract. It's very important. It goes back to our previous class of contract law. Always sign a contract. Have something written. Though if you have witnesses, the oral can also be okay. If you can bring in witnesses, if someone's going to give you a duty to do orally, have some witnesses. So that in case you go to court, you can have witnesses. You can say, no, I have a witness, so and so was there. Okay, when you say this and this. Yeah, so Sunny, I hope that answers your question. It's possible.
Yes, it's answered my question.
Yeah, it's possible.
Okay.
So if it's going to be oral, make sure you have witnesses, like 3 witnesses. Okay, have like 3 witnesses. They will count in court. If it's written, the document is very good. It's good enough, written and signed by the other person. Also, that signature must also have witnesses. Other people must have also signed that, because the person can claim that they signed under duress. So always have also witnesses that sign on that document. Okay, at least 3. Okay. So the other last one is the duty of care. Supposed to, as an agent, you're required to have some care, okay, in the way you perform your duties. Don't just do things haphazardly. If someone has trusted you with a job, okay, kindly do it to the best of your ability. Do it 100%. Okay, it's demanded. It is just ethical. Okay, that you do that job 100%. Don't do it halfway. If maybe some people usually, when they've been given a job, they usually say, "But that's little. They gave me little money, so I'm just going to have things." Why do you accept to even take the job if you feel you're not satisfied? So my take on that, I don't know what your take is, because this comes back to ethics. But for me, I feel like if I've accepted a job to do, if a client has given me something to do for them, I want to do it 100% very well, despite of the pay. Okay, because most of the time it is usually pay. Then some people say the working conditions are poor. Maybe my boss is rude, or something like that. My client is rude, so I'm not going to do the best job. But it is you who decided on that job. Okay, so you have to do to the best of your ability. Okay, so that is duty of care. That's what I usually take. Okay, I think these are the responsibilities that you're going to do. So you have to pay reasonable remuneration. That's what I was talking about earlier. The pay is very important. Okay, how much are you paying for this job? Or how much are you paying your agent? Okay, so it comes back to how much the principal. Make sure your agent is well paid. Some of you are bosses, your managers, but you pay your clients very badly. You pay your employees very badly. So how are you expecting the other person to work if you're paying them not very well? So make sure your pay is reasonable. Okay, and also indemnify the agent from expenses. That means that don't put any expenses on the agent, like transport, feeding. Make sure you're taking care of those. If you've hired someone to do a job, make sure you make them comfortable. If for example, like I'm working online, make sure you've given me data. So I don't incur my own costs for data. Okay, so that kind of thing. So indemnify the agent any expenses. So you guys, I know you're managers, so you're going to do all that. And then termination of the agency relationship. Okay. When do we terminate relationship? We are going to terminate this agency depending on the time given. Maybe the project was for 2 months, 2 years, 5 years. So it's going to end at the end of that project. Also, you can end the relationship on when either party gives notice. Okay, so either the principal can give notice, or the agent can give notice of the end of the relationship. And also, you can also give circumstances. You can end the relationship according to the circumstances. Maybe the work conditions are no longer favorable. Maybe the salary is no longer favorable. So you can give reasons for terminating this agency. Sometimes people become insane, like they can't work anymore, or the company becomes bankrupt, so you cannot work for them anymore. So those are some of the reasons for the end of or termination of the agency. Yes, Sunny.
Madam, so now how do you notify the public when you have ended the relationship with your agent? Because I think like the agent can keep on acting on behalf of you when you don't want him to do, because especially when it has something to do with money, like he's getting money from people and then you are no longer in a relationship with him. So how do you notify the public that this agent is no longer with me, so that they don't deal with him in anything that has to do with you?
You use media. You use the media. You use mass media. Use newspapers. Use the websites. Use all kinds of media to inform the public. Legally, we're supposed to publish in the newspapers that we no longer, this person, I think you've seen sometimes in the newspapers that this person is no longer part of the company.
Yes, yes. So
Yeah.
now when you notify through the newspaper and then the guy did not see it, then he went ahead and gave the agent money. So who is going to be liable for that?
You bring out that document where you published. Okay, like no, we published in the papers. usually papers are the best, and your website. You can also put it on your website. Okay. So if someone continues dealing with the other person, it will be under their own risk. Okay. So that is what you do. So if the clients continue reaching the other person, and then they fall into problems, you bring out what you published. Like, no, we published in the papers about that person, so you were dealing with it at your own risk.
So it's actually a good idea whenever you are dealing with agents, you have to confirm that the relationship has not been terminated.
Yes,
because now
very much
if you don't know, and then they just go ahead and take it.
Very much so. Okay. So we have some legal forms of business. We have sole proprietorship, partnership, and corporation. Sole proprietorship is when you have one individual carrying on business, okay, on his own. So if you decide to open your own company, that is a sole proprietorship. Okay. And then a partnership, in partnership we have two types of partnership. We have limited, and then we have limited liability, and then general. Okay. So in general partnership, usually, let me go there. In general partnership, it's the usual partnership. It doesn't need a lot of legal documents to start a general partnership. It's almost like a sole proprietorship, but you come up with some kind of relationship that brings in profit. Then that's a general partnership. Okay, like this one, which is on my screen. Okay, if you come in partnership with, like Sunny, I come in partnership with Sunny in our software company. That is a general partnership. Okay, whether we've written it down or the way we are acting. Remember, in agency, okay, the way we're acting together, that makes a general partnership. However, a good evidence would make sure that at least we register that company. Okay, we try to register the company with a name. We try to register the company with a name. Then in a partnership liability, this one, we are liable to debts of the other partner. If the other partner incurs any debts, maybe borrows on behalf of the company, we are liable to pay for those debts. Okay. So liability, the word partnership, the liability means that you're liable to any debts. So if Sunny incurs any debts, I'm also going to pay for them. Okay. Any negligence, any misapplication of trust funds, I'm liable also to pay. So we shall pay as a partner. Okay. So each partner becomes an agent of the other. Okay. Then termination of partnership is like terminating the agency when one person dies or on notice, something like that. It's similar to what you've been looking at. Then in limited partnership, here we have we get like maybe capital contributions. Maybe I can say each one is going to contribute 50,000 in this partnership. Okay, but we have to have one person who contributes more. Okay, sorry, 50% for each partnership. So Sunny brings 50, I also bring 50. However, it doesn't work like that in limited partnership. In limited partnership, one person has to have a higher contribution, maybe like 60%. I can have like 60%, Sunny has like 40%. So there has to be always someone who's higher in a limited partnership. So it's similar to general partnership. However, in this one of the partners has to have a higher share. There's always that person who has a higher share than the rest. Okay, so that one becomes like the overall boss, okay, of the company. But the rest of the things usually are similar to the general partnership. So we call that limited partnership. Now we also have limited liability partnership. This one is a special form of partnership given to lawyers and accountants. Okay, you've been like to a business firm for lawyers on this and this company advocates. Okay, then we have also those SCCA guys, CPA guys. Okay, those lawyers at CPA. They have a special kind of form of partnership whereby it's tied to a written agreement that designates that partnership. So this one is given to professionals. So I'm guessing even software engineers can fall in here. So this is a professional kind of partnership. You come together as a professional, okay, a professional group, not just as any business group. So this is a company for lawyers, or a company for partners, or a company for software engineers. Okay, so this kind of company is called a limited liability partner. Okay, then the last kind of form of business. So we've looked at sole proprietorship. We've looked at partnerships where there's general partners, limited liability partners, and limit liable partners.